Hey everyone, and welcome. Today, we're going to talk about something that, on the surface, seems pretty simple. But trust me, it's packed with some really critical details. I'm talking about how you legally own real estate. We all have that dream of getting the keys to our new home, right? But that piece of paper that comes with them, the deed, well, it holds a lot more power and, frankly, a lot more complexity than most people ever realize. All right, let's get into it. Okay, so picture this. You've done all the hard work. You've navigated this crazy market. You've found the one. But just when you think you're at the finish line, the paperwork comes. And suddenly you're faced with this choice. A choice that's going to affect your future, your finances, maybe even your family for years to come. And it all comes down to this one question. How are you actually gonna own it? This is not some minor detail, folks. It's one of the single most important decisions you'll make as a buyer. And in a place like Texas, it pretty much boils down to three main ways you can go. You can own a property all by yourself, you can own it with other people, or you can get a bit more sophisticated and place it in something called a trust. And believe me, each one of these paths has its own set of rules, its own benefits, and yeah, its own potential headaches. So let's kick things off with the most straightforward path, the one that's easiest to wrap your head around, buying a property all on your own. In legal terms, this is called ownership in severalty. Now, I know that term severalty sounds a little weird, right? But the key is in that root word, sever. Because as the sole owner, you are legally severed. You're completely set apart from everybody else. And this applies whether you're just one person, like Doug buying his dream vacation condo, or if you're a single legal entity, like a big corporation buying a rental home. As far as the law is concerned, they're both treated as a single, solitary owner. And this way of owning property comes with a really simple trade-off. On the one hand, you've got total, absolute control. You want to paint the walls neon green? Go for it. You want to sell the place tomorrow? Your call. You don't have to ask anyone for permission. But, and this is a big but, the flip side is total responsibility. Every single bill, every repair, every bit of liability, it's all on your shoulders. All right, so that's the solo route. But what if you're not buying alone? I mean, what happens when two or more people, or even two companies, buy a property together? Well, now you've just entered the world of co-ownership. And this is where things get really interesting and the options really start to open up. The phrase you absolutely have to understand here is undivided interests. It sounds technical, but here's what it means. Let's say you and two of your friends buy a three-bedroom house together. You don't each own a specific bedroom. That's not how it works. Instead, all three of you own a piece of the entire property. You all share the right to possess the whole thing, from the front door to the back fence. Now, co-ownership usually breaks down into one of two forms. And listen up, because the difference between them is huge, especially when we're talking about what happens after you're gone. The default option in Texas is something called tenancy in common. With this one, your share of the property goes to your heirs when you die. But with the other option, joint tenancy, your share automatically goes to the other owners. That one single difference has massive, massive implications. And that really gets to the heart of what tenancy in common is all about. Think of it as an estate of inheritance. Basically, your share in that property is treated just like any other asset you own, like your car or your bank account. When you pass away, it's just another thing that gets passed down to whoever you've named in your will. This right here, this is the secret sauce, the magic ingredient of joint tenancy. It's called the right of survivorship. And what it does is completely bypass your will and the whole probate court process. So if you and your sister own a house as joint tenants and she passes away, her half automatically, instantly becomes yours. Her will has absolutely no say in what happens to that house. Now, because that right of survivorship is so powerful, the law is really strict about how you create a joint tenancy. You have to meet these 4 conditions, known as the 4 unities. The easiest way to think about it is like a checklist. You all have to get your ownership at the exact same time, from the exact same document or title. You have to have equal shares or interest, and you have to have equal rights to use the property or possession. If you miss even one of those, guess what? It's not a joint tenancy. You hear this phrase a lot, and it really sticks, doesn't it? A poor man's will. And it's called that because, well, it's a super simple, direct way to pass a huge asset, the property, to your co-owner without all the complexity and cost of going through the legal probate process. It basically accomplishes a very specific inheritance goal right there in the deed itself. Okay, let's switch gears a little and talk about a special case. This is something that applies to married couples in Texas and a handful of other states. It's called community property. And the whole idea is built on the concept that a marriage is, at its core, a partnership. And to really get how this works, let's walk through a quick story. So meet Sarah. She's married to a guy named Bill. Now, during their marriage, Sarah's aunt passes away and leaves her a house in her will. So the big question is, who actually owns this house? Well, the house itself is what the law calls separate property. And the rule on this is super clear. Anything you owned before you got married, or anything you personally receive as a gift or an inheritance during the marriage, belongs to you and you alone. So that house, it belongs to Sarah, not to Sarah and Bill.
But here's where it gets tricky. Sarah and Bill decide, hey, let's rent out my aunt's house. So now this separate property is actually generating income, right? And that income is being collected while they are married. And that changes things.
This is where the law makes a really crucial distinction. While the house itself stays Sarah's separate property, the income it generates during the marriage, that becomes community property. That rent money belongs equally to both Sarah and Bill. It's a perfect example of how one single asset can produce two totally different types of property. So we've covered owning it alone and owning it with others. But beyond that, there are even more advanced ways to hold property, especially if you're thinking about things like estate planning or serious real estate investment. Let's just touch on these for a minute. So instead of owning it in your name, you could place the property into a trust, where someone called a trustee manages it for your beneficiaries. Or you could have a business own the property, anything from a simple sole proprietorship to a partnership, or even a full-blown corporation. Now, each of these gives you different layers of liability protection and potential tax benefits, which puts them all firmly in the "you absolutely need to consult a professional" category. Okay, so after running through all of these different options, let's bring it all back home, so to speak. Why does this one little choice on a deed have such a massive, massive impact on your life? It really all comes down to these four key areas. Your choice of ownership is going to dictate who inherits the property. It's going to determine who is liable if something goes wrong. It defines how much control you have over your share of the property. And finally, it affects how the whole thing is handled for taxes. These are not small details, right? They're absolutely fundamental to your financial well-being. And that brings us to what is probably the single most important piece of advice in this entire explainer. Because the consequences are just so significant, you should never, ever make this decision by yourself. Always, and I mean always, talk to an attorney and a tax advisor to figure out which of these paths is the right one for your specific situation. Because at the end of the day, how you take title, it isn't just a legal checkbox you tick on a form. It's a decision that literally writes a story about the future of what is probably your biggest asset. It's a story about your legacy, your partnerships, and your plans for the future. So the real question to leave you with is, what story do you want your deed to tell?